WOCA.
WOCA.
This is a demonstration of Ustream Producer.
All right, 25 minutes before 11 o'clock. Thank you for tuning in. John Fuller is in the studio ready to answer your questions. Today is Wednesday, November 28th, 2012. I mentioned the date because sometimes John is in court and can't be here, and we run a rebroadcast. So if your date on your calendar says Wednesday, November 28th, 2012, then you're listening to a live show, and we invite your phone calls. If you have not a political issue, if you have a legal issue that you would like to have John take a look at, call it in. Let us hear about it. The phone number is the WOCA Climate Control Source Hotline, 622-9622. John Fuller is your host, of course, and he's an attorney with his own law firm, the law firm of Fuller & Fuller right here in Ocala. Good morning, John.
Good morning, Larry, and good morning to all of our listeners. I hope you and everyone listening had a very happy Thanksgiving holiday. We were not live last week because I was out of town,
right.
It's very nice to be back and chatting with anyone who may be listening to us who has a legal question. We certainly encourage you to give us a call, and we will talk about the general principles of the law on this show, as we've enjoyed doing for over a year now. As I have said many times, legal issues resolve around the specific facts of each individual case. And if you've been in an automobile accident, or if you have some commercial or business litigation question, that falls in our area of specialization. We'd be happy to see you if you want to call us. Our office number is 352-547-4292 here in Ocala. My partner and wife, Janet Fuller, specializes in Social Security disability claims. So if someone feels like they have a claim for Social Security disability, certainly we'd be glad to try to help them in that regards if they would call the office and make an appointment. Otherwise, anything that anyone has a question about that involves any aspect of the law, to the extent that we are able, we will be happy to address it. If it's something that is out of our area of expertise, then we would encourage them to speak with a lawyer who specializes in that particular area. One of the things that has been very, very prominent. Well, I see. Is that a phone?
It's not our line.
It's not our line. No. Okay. Well, I didn't want to be keeping anyone on hold unnecessarily. But one of the new things that we've talked about before was the dramatic change in July in the automobile no-fault insurance law for people who have purchased insurance and have purchased personal injury protection to pay for their medical bills in the event they are in an accident, an automobile accident, regardless of who is at fault. And ever since that law went into effect in the early 1970s, that amount of coverage that came with the policy that you purchased was generally $10,000. You may have gotten a higher deductible if you chose to, but generally speaking, it was $10,000. In July of this year, the Florida legislature, at the urging of the governor and the insurance lobbyists, greatly eviscerated that law and changed it. It now provides that if you are injured in an automobile accident, you must seek out medical attention by a doctor, a doctor's physician's assistant, or an advanced registered nurse practitioner, or a doctor of osteograph, in order to get your coverage for your medical bills paid for. You can no longer go to a chiropractor as your first treating physician. Furthermore, and what's even more troubling, and I just ran across a situation like this a week or so ago. Lady was in an accident, was hit from behind, was shaken up badly, had substantial pain in her chest area based upon coughing, breathing deep,
wow.
really, really, really bad. She perceived she had
Ustream producer.
broken some ribs, but she was just trying to tough it out.
Yeah.
And I spoke to her and I said, have you been to the doctor? Have you seen a doctor? Have you had any x-rays taken?
Oh, no.
No, I haven't. Well, fortunately, it was within the 15 days.
Oh, okay.
So she went to the doctor. She not only had about 4 broken ribs, but she was developing a condition known as pleurisy, which is an inflammation of the pleuratic lining of the chest cavity, and could have very easily gone into pneumonia. And so, by virtue of having gone to the doctor certified that she had a significant medical event, and that's a critical term. Because if you don't see a doctor within that first 15 days, and if that doctor doesn't certify that your injury is a significant medical event,
Right.
the law automatically strips you of the $10,000 coverage that you paid for personal injury protection and caps your coverage at $2,500. Now, there's not a lot that you can do for broken ribs except suffer them through them until they heal.
Right.
However, if that had punctured a lung, if it had developed pleurisy, if it had developed into pneumonia, and the 15 days had gone by, she would have only had $2,500 in no-fault benefits, which would probably have not covered all of the x-rays that she needed. So I want our listeners to be aware of these things. The rhetoric that gets caught up sometimes in the political system is very misleading. And this law got passed. I think it was called Truth in Insurance or something like that, under the argument that there had been too many fraudulent claims. And like everything, there's abuse in the system. I'm not suggesting that there hasn't been,
Right.
but I do want people to know that they have valuable rights, and if we can do a little bit on this show to educate people to make sure that they don't inadvertently waive those rights, that will be an important factor.
I don't know if this applies, but if you go, like using her as an example, if she hadn't gone and the rib had punctured a lung versus the fact that she has gone to the doctor in the 14-day period, after the 14-day period, if the broken rib creates further complications, whether is she still covered?
Out of luck. She's out of luck if she hasn't sought medical attention.
Okay.
Within,
but the fact that she saw the doctor in that 14-day period,
yes.
So now if something later happens, is what I'm trying to say.
Yes, but the doctor also has to causally relate it back to the accident.
I got
That's
you.
a very, very interesting point that you raised. And those things do emerge. The older we get, the more fragile we become, the weaker our immune system. Yeah. If you don't deep breathe, because it hurts, you have a higher likelihood of developing pneumonia. Well, we know that many people get pneumonia who are never in automobile accidents. But when you are in an automobile accident and you have 4 broken ribs, and then 2 weeks, 3 weeks later, you develop pneumonia because you've been giving in to that pain and breathing very shallow breathing, and your lungs have not been cleared. You haven't been able to cough, those types of things, and you develop pleurisy or pneumonia, which can be very painful and very serious, and then you go to the doctor and the time frame has expired, you don't get your no-fault benefits.
That underscores the importance of it.
It really is, and it's important that the physician that you see or the medical practitioner certified a significant medical event. If a busy emergency room doctor sees you and doesn't certify it, you're still stuck.
Oh no.
Yes.
So you might think.
Unless you go, and that's another reason, if you're in an accident, to make sure that you ask the law enforcement officer who's investigating the accident to fill out a long-form accident report rather than a short form. many times they will try to do the short form because it saves time.
Right.
And if it's not a major-looking accident, but people can be severely injured in low-impact collisions too, especially if it's a senior citizen who, if it's someone who has osteoporosis, they may have thin bones and are more fragile as we get older. Our bodies tend to be less resilient and more fragile, and so a low impact that may not look like much on the face of how much damage is done to the car. The individual needs to ask them, because the lawyers who are defending automobile insurance carriers will no doubt develop an argument that will say, now, officer, you didn't even bother to fill out a long form accident report. You have a much more involved form to use when it is a significant impact, when it's a major accident. But for little trivial fender benders, you just use the short form. So when you were there, you just used the short form, didn't you? And then argue, if this had been a significant event, sufficient to cause a significant medical event, they should have used a long form. So I would suggest to people, it doesn't take the officers that much extra time, and they're trained and they're very familiar with all the little boxes to check. And that's just one other way that you can protect yourself.
Oh, wow. Good information. I hope that word spreads. John, you do have a phone call, and everybody is welcome and invited to call John Fuller. The number here is the WOCA Climate Control Source Hotline, 622-WOCA. Good morning. Thank you for your patience. You're on the air now with John Fuller.
Yes. Good morning, Mr. Fuller.
Good morning, sir. I hope you and your family had a nice holiday, and it's nice to talk with you. Thanks for calling.
It was a great holiday.
Good.
Thank you.
Great.
If a couple, both U.S. citizens, travel to a different country, a foreign country, and get either married or divorced, is it legally live? Is it good in this country? Is it valid? And if it's not, how would you make it valid?
Wow, that is a super sophisticated question that involves a tremendous number of different issues. Generally speaking, if the divorce is valid in the country in which it is rendered, our country will give full faith and credit to the court orders of other jurisdictions. There is something known as the Hague Treaty, and countries that have adopted the Hague Treaty give reciprocity to each other. But not all countries have subscribed to the Hague Treaty, the Hague being in the Netherlands, and they have a treaty that basically says that if a divorce is valid in the country in which it was issued pursuant to the laws of that country, then it would be recognized in those countries that have subscribed to that. Interestingly enough, Egypt, for example, has never signed the Hague Treaty. So they would not recognize Florida court orders or judgments. If you are in a jurisdiction that is recognized by this country, and if you are living here and your spouse is living here, and there is an issue that comes up such as child custody, modification of child support or alimony, or some issue that the court has continuing jurisdiction is, the way you approach that is you have to file an action in Florida under the Florida statute that allows you to what is called domesticate a foreign judgment. And you get an authenticated copy of the foreign judgment, you file an action, you attach a copy of that, you serve the party who is the opposing side with a copy of your complaint to domesticate the foreign judgment, and the Florida court would then domesticate that judgment, and then it would have the force and effect of a Florida.
To it, huh?
And I'm probably missing some things too, sir. Let me tell you, this is you are absolutely right, and I would not want you to think that was the last end all be all of that question. It depends, and I am certainly not an expert in international law and or immigration law. and those are very, very specialized areas. So if someone has a question, they need to find a lawyer who specializes in that.
Would the legality of marriage in a different country be a little easier to be accepted here?
I'm not sure I understand. If a person is legally married
in a different
country, yes, and it's married in accordance with the laws of that country, I believe that the marriage would be valid and recognized in this country.
Okay, is it just a matter of going to the courthouse and saying, get some paperwork on that to legalize it, or any kind of?
Well, I'm not sure that you actually need to do that. If there's if everybody's living happily ever after, and you're legally married in a different country, yes, it's a valid marriage, and this country would accept the marriages of other countries as valid.
Yeah. Now, if you're legally
now the one thing that is kind of interesting. Florida does no longer recognizes what is known as common law marriages, where two people without the benefit of a marriage license or a marriage ceremony or being married by anyone with legal authority to marry them just live together and hold themselves out as husband and wife. Florida used to recognize common law marriages, but they haven't done so in many years, back I think in the early 60s. However, they are still, as far as I know, at least one and perhaps two states that do recognize common law marriages.
Okay.
The last time I looked, Georgia was one of the states.
Oh, really?
So if you have a valid common law marriage that arose in a state with a law that recognizes the common law marriage as valid, and if you comply with the elements of what you have to do to establish a valid common law marriage in that state, such as living together, holding yourself out publicly as husband and wife, intending to be married, etc., if you do that, then you move to Florida. Even though you did not have a wedding license and did not get married, and that would not have been a valid marriage had you done the same things in the state of Florida, because Georgia recognizes it, then Florida does give full faith and credit and recognizes, it's sometimes called judicial comity, comity, not comedy like a comedian, but comity, comity, which means judicial back scratching. You recognize our laws, Georgia, and we recognize your laws. Same type of situation in like, for example, the laws that allow citizens to carry a concealed weapon. Most states now, all except for maybe 3 or 4, have laws now that allow their citizens, if they comply with the law and meet the requirements, to have a permit to carry a concealed weapon on their person. Those laws are generally given reciprocity, but you need to check them carefully because they vary from state to state.
Well, with this marriage and divorce situation, very complicated subject. You definitely have to contact a lawyer to have somebody that can straighten you out on what's going on, because you could probably get yourself into a lot of trouble if you wouldn't.
Absolutely. That's a specialized area. It's a complex area, and it is an area that is not regularly dealt with in the mainstream practice of law, especially in a city like Ocala. If you live in a city where there's a big foreign population, say Miami or New York or somewhere where there's a lot of immigrants, it probably comes up far more often. But we don't see that as the part of the normal day-to-day practice of law in this area.
Okay, well, thanks for your answer on a very complicated question there. I appreciate it.
Thank you for taking the time to call. I always enjoy talking with you.
You bet. Bye now.
Bye.
And the number to call if you'd also like to call is 622-9622. That's the WOCA Climate Control Source Hotline. There was a story the other day, John. I wanted to ask your thought on it. And it said that the Florida Supreme Court allowed a woman who was the third car in a 3-car accident to have a jury trial because she felt like she was not completely negligent in hitting the second car. And the implication, according to the article, is that now it sets precedent so that if I'm, let's say, driving down the road and a squirrel runs in front of me and I step on my brake, the guy behind me hits me, I could be partially responsible for that accident, and he or she behind me has the right to take it to a jury trial.
Well, I think that's, to some extent, always been the law in Florida for at least for a considerable period of time. I shouldn't say always. In our body of negligent law, which is what automobile torts arise out of, negligence of one party who breached their duty of due care to act in a reasonably prudent manner, and as a result of their failure to do so, they caused an accident which caused injury and damages. That's basically the law of negligence. Florida has had a theory since the mid-'70s, or maybe even the early '70s, that's known as comparative negligence. So anytime there is an automobile collision, there is a jury instruction that the jury should determine whether or not the party who is being sued is negligent. If they determine no, that's the end of the case and everybody goes home, and the person who filed the claim, the lawsuit, doesn't get anything.
Okay.
If the jury answers that interrogatory verdict, is what it's called, with a yes, then the next question is, was the plaintiff or the person who's making the claim also at fault? And if the answer to that question is yes, then the next question is, what percentage of the overall negligence that caused the action was attributable to the plaintiff, and what percentage was attributable to the defendant? So even in any kind of a collision, there's an element of comparative negligence. A car that pulled out in front of an intersection, for instance, if they had the appropriate amount of time to clear that intersection, but an accident occurred because another automobile came over a hill at an extremely high rate of speed, in excess of the speed limit, and hit them in the intersection, then you have a comparative negligence question, because if car number 2 had not been speeding, there would have never been a collision, because car number 1 would have had sufficient time to clear the intersection.
That makes sense. Yes.
There's no question that car number 2 had the right-of-way to go through the intersection, and car number 1 had preempted that by pulling into it. So the jury could determine that each party was partially at fault. Then they go on and determine the measure of damages. What are your injuries? Medical bills, lost wages, pain and suffering, all of those things. And if they determine that, let's just say your injuries and damages are $100,000, but you are 50% at fault for causing the accident, then the person only recovers $50,000, and the judge reduces the verdict by a pro rata amount that is the percentage consistent with the negligence of the party who caused it.
And I'm guessing that the decision to take an accident, an automobile accident, to a jury has to, I mean, it has to be between you and your client, or a client and his attorney, I should say. I mean, you don't want to just say, "Oh, I'm going to take this to a jury." You've got to have somebody who knows, is this a good idea or not, right?
It is. Well, certainly you look at all cases very critically to determine what are the elements and what can you prove, and is it cost efficient. You may have someone who's injured, but the damages are so minimum that the cost of the lawsuit does not make it practically reasonably practical. Yes, and then also I want to say something else, that insurance adjusters for some companies are very, very good and conscientious about wanting to reach a reasonable settlement. When they see that their insured is at fault, oftentimes there can be a negotiated settlement where a trial is avoided. And if it is a fair settlement, that is far more preferable, because you know what you're going to get, you have closure and finality, and you don't run the expense, the risk, the uncertainty, and the delay that is inherent in the jury trial process. So the vast majority of cases are settled. However, they are, in fact, some companies that have a reputation of not wanting to settle cases because they have concluded that they can get a financially better bottom line for their stockholder by simply refusing to settle any cases, and people will become intimidated and will walk away without suing them, and they will end up putting more money in the corporate coffers. And so there are some companies who have a reputation for not trying to reach a fair and reasonable settlement. Other companies are far more reasonable in their approach to the system, and that's a part of business philosophy. And I'm not saying that those companies are doing anything wrong, or that's inappropriate, or that it's unethical. It's just a business model where they've decided that they can afford to say no to every claim and or offer such an insignificant amount of money that if somebody took it, it would be de minimis, and they can pay lawyers to defend them, and they'll win a certain percentage of those cases, or make it so expensive for the other side that they will not pursue it. And at the end of the day, the amount of money they've paid the lawyers to defend all these lawsuits is less than they would have paid out if they had settled them for their fair value. That's simply a business philosophy and judgment that each company makes on its own, based upon their company mores and their financial greed or conscience.
Again, John, you've illustrated why we need to go to see you when we have a legal issue. John Fuller's phone number is 352-547-4292. I remember John is partnered with his wife, Janet Fuller, who's not only an attorney, but also a registered nurse, and she works with Social Security.
Yes, Social Security disability. If you have no capacity to work, and you've been out of a job and can't work because of a physical injury or health problems, diabetes, high blood pressure, things that are so debilitating that you are not capable of any type of employment, Social Security may be your last best hope, and that's Janet's area of specialization. She knows every 100 times more than I do, because I don't practice in that area, and it's a very specialized area. But certainly, she's very knowledgeable in it, and would be happy to help someone if they had a question.
John, thank you for all you do for all of us.
Always a pleasure.
We'll see you again next week.
I hope to be here. Thank you very much.
We'll take a little break. Dr. Riyad Fakhouri is up next.
Ocala's information station, 1370 WOCA. Ocala.
The weather is brought to you by myfwc.com. Life jackets save lives. Wear it, Florida. Times of clouds and sunshine today, with highs ranging from 68 in the northern part of the